Welcome to the Norman Zindahl Studio. My name is Bill Messenger. I'm the Legal Director at the National Right to Work Legal Defense Foundation. Today I'm with Aaron Solem, and we're here today to talk to you about a process known as decertification. Aaron, can you just give us a brief overview of what decertification is and what it means for employees?
Sure. Decertification is the process by which employees remove a union from their workplace, a union that represents them, negotiates a collective bargaining agreement with their employer. When you have an exclusive representative or a union, they're the only ones who can negotiate with your employer the terms and conditions of your employment. When you decertify the union, you remove them from the workplace so you can negotiate with your own employer over your own terms and conditions of employment.
So let's just sort of take this step by step. Let's just say you're an employee, you want to decertify the union. What's the first thing you need to do? Let's step back a little bit. Under the National Labor Relations Act, let's say you're a private sector employee, because I know laws vary. So let's just talk about private sector employees at first. If you're a private sector employee under the National Labor Relations Act, which governs most private employees, what's the first thing you need to do if you want to decertify your union?
So the first thing, it's the most important thing you can do is collect a petition that says you no longer want the union to represent you. If you get more than 30%, if you're a private sector employee, you can remove the union from your work. You can ask for an election to remove the union from your workplace. If you have 50% or more, you can ask that the employer withdraw recognition without the need for an election.
Okay, so the first step in decertification is to get a petition signed against union representation. A sample petition can be found on the National Right to Work Foundation's website. It basically states that we, the undersigned employees, no longer want this union to represent us. So if I'm an employee and I want to circulate this petition, is there anything that I should know in terms of circulating it, how to get people to sign it?
There's a couple steps that you need to follow, and it's very important you follow these steps because if you don't, it could imperil your petition and imperil the election or imperil your efforts. So the first thing you need to do is collect a petition, and when you collect the petition, you should do so on non-work time, not when you're clocked in or working, and ideally in non-work areas where you work. You can collect it in a break room, you can collect it in the parking lot, you can collect it off-site, but make sure that you don't do it anywhere where you're actually working. The second thing you should do is not talk about it with management. Don't discuss it with your supervisor, don't discuss it with the owners of the company, because doing so could potentially imperil your decertification efforts. There's a lot of little variables that you have to deal with, which is why it's important to call the foundation and to ask to speak with one of our attorneys who could kind of help you through these steps.
So if I'm an employee and I've collected a petition from my coworkers to say we no longer want the union to represent us, as you mentioned, this should be done on non-work time and in non-work areas without management assistance. But you have this employee petition against the union. If over 30% of employees have signed it, what's sort of the next step in decertifying the union with that petition?
If over 30% of employees have signed it and you want to seek an election, you have to go to the National Labor Relations Board. The National Labor Relations Board is a government agency established by Congress nearly 100 years ago, and they're the ones who conduct secret ballot elections for private sector employees. So once you collect 30%, you can go to the NLRB's regional office in your area. You can give them the petition that you filled out, the signatures. You fill out a form, and then you serve it on the other parties as well. After that, in an ideal world, the NLRB will start to investigate the petition, and if they find that you have 30% and they find that you've collected enough, say 30% from your bargaining unit, they'll order an election in 4 to 6 weeks generally. But that's an ideal world. We don't live in an ideal world. And often there's several roadblocks and different steps and permutations that can be put in the way. So it's important, if you do collect a petition, to try to get legal assistance from the foundation so we can help you through all of these process steps.
Yeah, the various process of turning that petition and actually turning it into an election and effectuating that. But before we talk more about elections, if employees have over 50% of signatures on the petition, meaning a majority of employees have signed something saying they don't want the union to represent them, they have another option besides an election, correct?
Right. What I mentioned earlier is withdrawal. So if you have 50% or more, then arguably the union has already lost majority support, and it would violate federal labor law for the employer to continue to negotiate with a union that lacks majority support, because the union is only in place because it has majority support. So you can take your petition to your employer and you can ask them to withdraw recognition unilaterally without the need for an election. This can be an easier step than an election because you don't need to have an election, but it can also be harder because it's less certain. Generally, an election settles things very quickly, it makes it final, but a withdrawal opens, it can be open the petition up to various legal attacks from the union and from the NLRB, which is why generally I tell people, if you can get an election, you should go try to get an election.
So if you have over 30% on your petition, you can get an election, which is usually the preferred route to decide what employees want. But if you have over 50% on your petition against union representation, that gives you the option of employer withdrawal. But for either type's decertification efforts, there's important time limits on when you can do this. Unfortunately, the National Labor Relations Board has created a number of restrictions, what they call bars, on when employees can decertify a union. You can't just sort of do it anytime you want. And there's three main bars we're going to talk about. The first is the certification bar. Could you describe what the certification bar is?
Right, as I said, in an ideal world, you'd get an election, but we don't live in an ideal world. And so there's only certain times when you can get an election, and the first is the certification bar. Certification bar says after a union has been certified in an election, so if you had a secret ballot election conducted by the National Labor Relations Board, after the NLRB certifies that as a proper election and says the union wins, the union gets 365 days to negotiate a collective bargaining agreement. If there's no collective bargaining agreement at the end of those 365 days, only then can you go collect a petition and file for an election.
So basically, if the union just won an election less than a year ago, you can't decertify until at least a year has passed from the certification. But now let's just say the union came into power without a secret ballot election through what's known as a card check campaign, where the union collects cards from employees and gets the employer to recognize the union without an election. When can employees decertify after they've been unionized under a card check?
Right, so right now the rules about when you can decertify after a card check are in flux, but right when we're recording this, if a union has come in through a card check or through a voluntary recognition process and there was no election, if the employer has not put up a notice from the NLRB that voluntary recognition has occurred and that you have a right to an election, you can seek an election at any time. However, if they put up this notice from the NLRB that says you have the right to seek an election, you can only seek that election for a very short time frame, and then a bar comes back into place for a certain period of time. Now, the NLRB is trying to change these rules, and it's trying to say after a union has been voluntarily recognized, the union cannot be challenged for 6 months after the start of bargaining. So bargaining has to start. You have to wait 6 months, and then you can file a petition. But between 6 months and a year, you won't necessarily get an election because it's subject to a complex 5-part test. So it's like I said, in an ideal world, you'd get an election, but we don't live in an ideal world. And so what'll happen is, you'll have to litigate over these issues.
Yeah. So if you've been subjected to a card check and you want to decertify that union, request an election, your best bet is probably to contact attorneys at the National Right to Work Foundation to evaluate your particular circumstance. Because as Aaron indicated, right now the law is in flux. What's allowed right now may not be what's allowed in a few months. And under what's probably going to be coming in a few months, that process is somewhat tricky. And the final bar I want to talk about is the contract bar. That's a real impediment for employees in places that have been unionized for a while. So can you discuss the contract bar rule on decertification elections?
Right, so if an employer and a union agree to a contract, employees are barred from decertifying the union for either the length of the contract or up to 3 years. Now, generally most collective bargaining agreements are either 3 years or 5 years. And so you can only move for an election once every 3 years. And you can only move for an election 30 days at the end of the agreement once every 3 years. For the vast majority of employees, you can move for an election 60 to 90 days before the third year expiration date of the contract, or technically from the beginning, the 3rd year anniversary of the beginning of the contract. If it's 5 years, you can move for an election anytime after the 3rd year anniversary of the contract. But again, there's various permutations. Not all contracts are what the board calls are a bar quality, meaning that there's various deficiencies in the contract that stop them from becoming a bar to an election, which is why, again, it's important to call the foundation and talk to an attorney and see if there's you have an individual situation where you could possibly obtain an election despite there being a contract in place.
So let's just say an employee, they're able to get the 30% at least on the petition. They're not barred by any of these restrictions, not by the certification bar, recognition bar, contract bar. They timely file a request for a petition, and the NLRB decides to hold an election. Exactly what does a decertification election look like as a practical matter, and what can employees do during that election?
You know, the vast majority of time, decertification election looks like any secret ballot election that you have in the political process. What happens is an NLRB agent comes, they set up a polling station, you go to the polling station, you have a secret ballot, you fill it out, you put it in the box, they open it up, and they count the votes at the end of the voting period. Now, sometimes, especially during COVID, there were mail ballot elections, although that's becoming more rare. It tends to be more in person now. But another important thing to remember for employees is that you have the right to campaign. You have rights under the National Labor Relations Act. You have free speech rights to oppose unionization. And so if you have a decertification election, you filed for it, or you're an employee and somebody else has filed for that election, you have free speech rights, and you can go out and you can campaign against the union just as much as the union can campaign for itself, or the employer can speak out on its own views.
So it's a lot like a political campaign. Both sides will be campaigning, trying to convince people of how to vote in the secret ballot election. However, there is one difference, unfortunately. Usually in a political election, after the ballots are counted, that's the end of the matter. That's not necessarily the case under the National Labor Relations Act, isn't it?
No. Oftentimes what you'll see is if a union loses an election, they'll file what are called objections. Now, 7 days after an election, the union has the ability to file and say, hey, there's something wrong with this election. And the NLRB says, well, we want our elections to be so pristine. They have to be conducted in what are called laboratory conditions. It has to be clean. So if the employer did something wrong, or even if outside forces did something wrong, it's possible for the election to be overturned and rerun. In addition, the board lately has indicated that it wants to rerun fewer elections, and it just wants to reimpose unions on employees through what are called bargaining orders. Now, these are rare, and they generally don't happen after decertification elections, but the board seems to be creeping in that direction to their use. We're going to see their use more often, possibly in decertification elections. It's just something that you have to watch out for.
Yeah. And Aaron's alluding to a recent decision by the National Labor Relations Board called CEMEX, which came down in September of 2023. And in that decision, the board basically said, if an employer commits even one unfair labor practice during the course of an election, that could be grounds for just throwing the entire election out and installing the union in power during a card check campaign if the union just came into power. The CEMEX rule doesn't always apply, at least under current law, but it's something to watch out for. That under the National Labor Relations Act, winning the election at the secret ballot, winning it at the polling place, doesn't necessarily mean the game is over. There can be litigation afterwards about that election. And overall, the NLRB process can seem fairly daunting and rigged against employees. But employees have successfully decertified unions on many occasions, correct?
Yeah, it's a tough process to decertify because a union can seek an election at any time. But as we've kind of discussed here today, there's only certain time periods once every few years where employees can seek to decertify the union. So the DAC is stacked against individual employees, but it's not insurmountable. It's something that can be overcome, but it's important to have a guide along the way, which is what several of us here do at the foundation. We just help individual employees navigate their legal rights and through this complex process.
Yeah, and the Right to Work Foundation has represented countless employees with respect to decertification, walking them through the procedures, helping them obtain an election. And many employees have successfully decertified unions with foundation assistance with the legal process. So it's a daunting process to decertify, but it's certainly a realistic one and far from impossible. Now, so far we've been talking about how decertification works for private sector employees under the National Labor Relations Act. Some employees, however, fall under different laws. If you work for an airline or for a railroad, you're under a different federal law called the Railway Labor Act. If you're a public sector employee, a public school teacher, state employee, you're under those state labor laws. What does decertification look like for employees under public sector laws or Railway Labor Act?
Well, under the Railway Labor Act, it's slightly different, and there's some complications that are probably too much for a video. But it's so if you are an RL employee who works for a railway or an airline, it's probably important to call the foundation and talk about how to get an election. If you work in the public sector or under a state labor law, most of the time those mirror the National Labor Relations Act, but not always, which is again why it's important to seek legal counsel.
Absolutely. And I think that's probably one of the main takeaways today. You can do decertification on your own. A lot of times you can build your own house. But it's much easier with an experienced professional guiding you through the steps and how to do it. So if you're an employee, who wants to decertify the union and you believe your coworkers may support that effort, we urge you to contact the National Right to Work Foundation for more information. You can do so on our website, which has sample petitions, sample showing of interest, and information about decertification, and also an ability to ask the foundation attorney to call you back or contact you back to inform you about your legal rights to decertification and provide you with free legal aid and information on that topic.